Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video. Today I want to talk about charging orders. What is a charging order? And if you're in business, why would you need to know about charging orders? Okay, let's just start with some basics. It's often the case that people hear that they should operate their business in a separate legal entity rather than own the business in their own names for liability protection reasons. For example, if you operate any kind of business, you probably don't want to operate it just as an unincorporated, non-separate legal entity business owned in your own name, because if the business does something wrong, either acts negligently or breaches a contract with someone, and if the business is owned solely by you in your own individual name, all of your own personal assets are going to be at risk when the company or the business gets sued. So typically people will either incorporate their business and operate it as a corporation, which is a separate legal entity from them personally, or they will set up an LLC or a limited liability company and operate their business as an LLC. Again, it's a separate legal entity. So if the company or the business is sued for any kind of negligence or breach of contract action, then the personal assets of the owners, either the shareholders of a corporation or the members of an LLC, are protected from having their own personal assets at risk. And so that's the main reason generally that people set up separate legal entities to conduct business, either corporations or LLCs. These days it's more often an LLC. And it's all in the name, the benefit from having an LLC, a limited liability company. But there's another benefit to LLCs that also provides protection to its owners, and that is in the arena or area of charging orders. So let's say that something happens and someone personally gets sued for some thing they did wrong, either negligent action or breach of contract or something, and that person gets sued personally, and the person that is getting sued gets a judgment against them. So that, let's just take an example. Let's say that you're in an automobile accident and you're at fault, you cause an injury, and you're driving the car, you get sued personally for that automobile accident injury. Okay, the person who sues you gets a judgment against you, let's say, and then they want to collect on the judgment. Well, let's say that you have property that is held in an LLC, whether it's real estate or some other type of asset. Can the judgment creditor, the one who has a judgment against you, get to the assets that are held inside that LLC? And the answer is that, at least in Tennessee, under current law, the exclusive remedy that someone has against collecting a judgment against an owner of an LLC interest with respect to assets that are in the LLC is that the judgment creditor can get what is called a charging order against the LLC. What that is essentially is it's a lien that's placed on the LLC that basically says when distributions would be made to the owner of the LLC or the owners of the LLC, that it's that the money that would otherwise, or the property that would otherwise be distributed to the owner of the LLC or the owners of the LLC would be diverted and be paid to the judgment creditor. It's like a wage garnishment for an employee of a company. When an employee gets a wage garnishment against him or her, then the employer is put on notice with the wage garnishment that they have to pay a certain amount of money from those wages to the creditor. Same thing with a charging order. the LLC is put on notice that it cannot make a distribution to the owner or owners of the LLC without diverting that distribution to the judgment creditor. But the judgment creditor cannot force the LLC to make a distribution. So essentially it is just a lien. So in that respect, a charging order provides some protection to a person if they have assets in an LLC and the owner of the LLC gets a judgment against him or her personally. What assets are in the LLC are essentially protected in some respects, because until the LLC makes a distribution or wishes to make a distribution to the LLC owner, the judgment creditor, all they have is a lien against the LLC. They cannot force the sale of the LLC. They cannot acquire the ownership interest of the LLC. They can just get a charging order, which is essentially a notice of a lien against future distributions that might come from the LLC. Now, in some states and in some places, courts and maybe even legislatures have seen that there could be some unfairness to judgment creditors if there is a single owner of an LLC, so that you have a single member LLC, because the policy behind having a charging order as a remedy for a judgment creditor is that it would be wrong for a judgment creditor to be able to go in and take over an LLC when there could be owners of the LLC that should not be affected by a judgment against one of the single members. But when you only have one member, it appears that it could be unfair for the judgment creditor not to be able to get to that LLC interest, since you only have the one owner. But at least as of now, the statute in Tennessee makes it clear that the exclusive remedy that a judgment creditor has against property in an LLC to satisfy a judgment against an owner of the LLC is to get the charging order. So you can see that not only are LLCs great for protecting the personal assets of the owners of the LLC. When you have an operating LLC and it gets sued, the owner's individual assets are protected because the business is operated in the form of an LLC. You can also see that an LLC is great for protecting property that's in the LLC from personal creditors of the owners, because all that a judgment creditor can get against the property that's in the LLC is a charging order. So charging orders are great things to know about. It makes LLCs not only important for conducting operating businesses to protect the personal assets of owners, but it also provides protection against for the property that's in the LLC in the event one of the owners gets a personal judgment against him or her. All right, I hope that helps. If you have any questions, please feel free to reach out. Again, this is Dan Smith at DPS Legal Counsel, and we'll see you next time.